But my main objective is to, make you look at mediation not as an ad hoc process, but as a serious means of fulfilling the constitutional promise of access to justice. Friends, we have this very remarkable document called the Constitution of India. It defines who we are as a nation and what are our aspirations for ourselves. Mr. Sriram Panchu said in one of once that the Constitution should be the collective common religion of the people of India. Now, all of you must have read the preamble, I'm sure, at least for 1,000 times, but let me still read out a part of it to refresh your memories. So it goes like this. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, which the focus of today's discussion is going to be mostly on this. Liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So mark these words, dignity of the individual. Now, in this context, I would also like to invite you to take a look at Article 39A, which was inserted, as you know, under the 42nd Amendment in 1976. It says that, Article 39A reads as follows: the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity and shall, in particular, provide free legal aid by suitable legislation or schemes, or in any other way. I want to emphasize on this, or in any other way, to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Now, as you can see under the preamble, we promise ourselves three kinds of justice: social, economic, and political. So if you look at these three kinds of justice, we are essentially talking about what is known as social justice. Just to broadly define social justice, we can define it as the fair treatment of all people in the society and the equitable distribution of resources among the people. So if you look at it from the perspective of this definition in the context of what the preamble talks about, human dignity, social justice has four essential goals. One is human rights. So everyone's human rights need to be protected. The other is access to basic needs like food, shelter, healthcare, education. There cannot be any discrimination in this. It has to be participatory. So everybody has the right to participate. Every citizen has a right to participate in the democracy. Every voice should be heard. And equity. Now, when we talk of equity, we normally confuse it with, sometimes people believe that equality is one of the principles of social justice. But it's actually equity. So what's the difference? Equity takes into account the effects of discrimination and aims for an equal outcome. I'm sure all of you would have seen this graphic of three people trying to see over a fence. I'll try to share that with you. So one of them is already tall and is able to see what is happening beyond the fence. There is a game going on there. Now they represent the most privileged in society. Now the other can just barely see. And the last person, the most, who can be called as the most vulnerable in society, can't see at all. So equity gives everyone one box to stand on. Equality gives everyone one box to stand on, even though the tallest person doesn't need it. And it still doesn't allow the shortest person to see, because just standing on one box, he's still not able to see over the fence. But equity doesn't give the privileged person any boxes. So instead, the middle person gets one box and the last person gets two boxes, so that now everyone is at an equal level. I'll just try to share that on the screen with you so that you can understand what I'm talking about. Yeah, as you can see now, equality is giving all of them 3 boxes, which doesn't serve any purpose because the first person doesn't need any box. The second person is just barely able to see over the box. And the third person, in spite of the box, is not able to see. But if you see the second picture, this is equity. So the first person doesn't need a box, so he's not given. The second person needs 1 box, so he's standing on 1 box. And the third person needs 2 boxes, and therefore standing on, he is given 2 boxes. Now, this is actually what we are talking about, is the larger aspect of justice that the preamble talks about. Now, there is yet another aspect that comes to mind when you talk of justice, and that aspect is resolution of disputes. Because we look at resolution of disputes also from the perspective of rendering justice. So apart from addressing the issues of social justice, our justice delivery system is also taxed with the responsibility of resolving disputes. Now, these include contractual disputes, commercial disputes, family disputes, community, religious disputes, so on and so forth. I'm sorry, my throat is a little bad, so please pardon me if suddenly you hear some Carnatic raga. It's just me trying to get control of my voice again, okay? Now, under the Constitution, we have created and established institutions for fulfilling this promise of rendering or ensuring justice. We have our courts. We have a hierarchy of courts, starting from the district Munsif to the Supreme Court, that deal with the whole spectrum of issues, starting from individual disputes to issues of social justice. Now, I'm sure all of you will agree with me if I say that a major part of the time of our superior courts, our high courts and Supreme Court, is taken up in resolving the individual, contractual, commercial, and family disputes than on addressing issues relating to or arising out of social justice. Now, let me just, I just want to talk a little about the legal theories on which, our legal system operates, on which our constitution is based. I hope you'll all agree with me if I say that, constitution is essentially a social contract. It's a contract that we have entered into with ourselves. It looks at justice as fairness, and it contemplates the establishment of a perfectly just society. So in other words, it is constitution upholds dharma. Now, I'm not using dharma from a religious sense, but only from the perspective of establishment of justice. So this is actually our constitutional framework, the structure that we follow is based on what is called as the social contract theory. That was propounded by some scholars like Immanuel Kant, Jean-Jacques Rousseau, John Locke. And John Rawls has written a book on this, which is called as a theory of justice. So this basically, this theory looks at justice as fairness, and it contemplates the establishment of just institutions, namely our courts and the other institutions, which are based on a unique set of principles of justice. So what it contemplates is that people's behavior has to comply entirely with the demands of the proper functioning of these institutions. In other words, people should be law-abiding citizens. So what this essentially means is that we have laws prescribing the rights and obligations, and people's behavior has to be strictly in accordance to these laws. All of you would have seen in our courts, some of our courts, we have this Latin maxim put up in the background. Fiat justitia ruat caelum. Let justice be done, though the heavens may fall. Now, here there's a challenge. It says justice should be done at any cost, whatever that cost might be. But if you see the ground reality, the actual behavior of the people does not always fit into the demands of the law. I'll just illustrate by giving you a couple of examples. There was, this is a case in which what happened was there was this couple who were very happily married. They had a lot of wealth. very wealthy family. The husband was very well off with a lot of assets, a lot of properties. Unfortunately, they were without a child. They tried everything, nothing worked, and finally it was, found out that it was because of some problem with the wife. Now the wife tells the husband, please get married again. You need a legal heir, so please get married again. Now the husband really loves his wife, and he doesn't want to uh, really get married again because he foresees a lot of problems coming up because of a second marriage. But somehow, as you usually wives have their way, and she convinces him. And I don't know how many men really need to be convinced to marry again. But anyway, what happens is he reluctantly, within quotes, he agrees and he gets married. And what happens is the marriage is going on, and the husband and the bride and the bridegroom are sitting in the mandap. And the first wife looks at this picture and she starts feeling uneasy. She thinks, what the hell have I done now? Have I axed my own legs? Here is this young girl, good looking girl, sitting with my husband. And in all probability, she is going to give him a child also. And what happens if she takes control of my husband and convinces him to throw me out? Time goes on, and it's found that this second wife is pregnant. She has conceived. And now, what happens, how people around you, friends, relatives, they all tell this woman that, look, what is going to happen to you now? What is going to be your future? What have you done? Why did you get your husband married again? So somehow she gets provoked enough to, a lot of issues, a lot of problems, a lot of fights happening in the house. Then she goes and files a suit for a declaration that the second marriage is null and void. Now, what happens if you apply the law to this case? Now, I don't have to tell you that according to the law, the second marriage, I mean, the parties are Hindus, obviously. So according to the Hindu law, the second marriage is obviously null and void, and the court is going to declare that. But how is it going to affect the people, the parties who are involved in this, the stakeholders? The whole family will be broken up. Because this woman convinces her husband to marry again, and after the marriage, she goes and files the suit. The husband is not going to forgive her for that. Now, it is going to damage the second wife's status because, always a court declaration in that, though she's a second wife, though she has no legal status, all that is taken. But when the court declares it, it becomes a real stigma. So, now what actually happened in this case, I will tell you later. Okay, now this is one example I'm telling you as to what happens when you apply the law, the ground reality of, the consequences of the application of the law. Because we say fiat justitia ruot caelum. Keep that in the background of your mind. Now, another example I want to give you. Now, these are all examples I normally give in my training programs, and I'm sure most of the people who have attended the training programs will be aware of this. Another is a partition case where there are two brothers, they are living together happily in a joint family. Everything is going on well, the family property is being taken care of. The second brother's, the younger brother's daughter gets married. And once the marriage is over, all formalities are over, the elder brother files a suit for partition and says that I want my share of the property. I don't want to live with my younger brother. Now, why he does it is because he feels that his younger brother did not give him enough importance that he deserved during the wedding and did not involve him in any of these discussions, or, did not give him the kind of importance that he expected him to, because he's the elder brother, the father figure. So he expects a lot of respect and, a lot of all the paraphernalia that goes, how you treat elders. So he feels slighted, he feels insulted, and therefore he feels that why should I live with my brother? I don't think this relationship is going to work out. So here again, if you see, if you apply the law in such cases, it may serve the ends of justice according to law. Now, I want you to observe this distinction. Justice according to law. But the question that arises for our consideration is, can it be regarded as complete justice? Now here, the problem, the anomalies that come up is, If you take, for example, the law prescribes shares of each family, member of the family in the inheritance. But the way our system works, it does not provide a remedy for the fissures that may have developed in the family. Or let's say that while allowing the dissolution of a partnership or the dissolution of a marriage, there is no mechanism to deal with the ill will that may have developed between the partners. So what we are doing is actually we are dealing with abstract principles. We are applying those principles to the people without understanding the fact that these are real people and they have real problems and they have real feelings. Now, additionally, also the law can be very confusing to people. To a layman, many decisions based on law may seem actually opposed to reason and common sense. I'm sure all of you would have come across this occasion when your clients tell you that I simply don't understand this. How can the court decide this in this way? It is against common sense. Now, according to their perception, you can even, they may call it as injustice. Now, if you have read this book, Oliver Twist by Charles Dickens, Mr. Bumble laments in that. He says, if the law supposes that, the law is an ass, an idiot. If that's the eye of the law is a bachelor. Obviously, Mr. Bumble holds bachelors in very low esteem, but normally the married people feel that they're lucky. So the law is a bachelor, and the worst I wish the law is that his eye may be opened by experience. So in other words, the application of the law, while meeting the requirement of justice from the institutional perspective, may not be seen as complete justice or justice that meets the real needs of the people involved. Now, I don't want you to think for one moment that I'm saying that the law and institutions are not important. They are indeed important because they are important for the enhancement of justice, because they facilitate a scrutiny of our values and priorities through a public discussion. Values such as right to life, right to education, right to free speech, right to information, right to equality, so on and so forth. Just look at the recent pronouncements of the Supreme Court. We need not go too far back in time also, ADM Jabalpur and all that, but we can understand the importance. For example, the Pattusami judgment on the right to privacy, the Sabrimala judgment and the Triple Talaq judgment on gender equality. So the list is endless. Now, if you look at our ancient past, we had two concepts. One was Niti and the other was Nyaya. Now, Niti relates to the organizational propriety as well as behavioral correctness, which is very close to our constitutional or the Rawlsian, what John Rawls talks about in his book, Justice as Fairness. So it is very close to the concept of justice as fairness and just institutions. So institutionalized justice is what Niti talks about. Nyaya is more concerned with what emerges from the application of Niti, how it actually affects people's lives in terms of how they are actually able to lead their lives. Now, this conflict between Niti and Nyaya is the conflict between duty and consequence. That is the application of law, fiat justitior vot caelum, and the consequences. So what happens if the heavens fall? You're doing justice, let justice be done. You're doing justice, now the heavens fall. So what is the consequence? How does it help anybody? So in his book, Amartya Sen talks, in his book, The Idea of Justice, Amartya Sen refers to the Mahabharata. And he says that when Arjuna, whom he calls as the consequentialist, a person who's worried about the consequences of the fight for justice, says when he was plagued by doubts about the potentially disastrous consequences of the war, Lord Krishna, who here is the deontologist, that is, he's more concerned with the upholding of dharma, duty, performance of duty. So he explains to him that his duty is to uphold the dharma by fighting for it. That is what the Bhagavad Gita is all about. So here, if you understand dharma as justice, it actually symbolizes the Niti idea of justice. So what happens? Arjuna fights. Now after the war, when there are dead bodies scattered all over, there are women who are widowed, women crying, children orphaned, crying over their dead. Now the question that comes to the mind was Arjuna right after all? Because the fulfillment of dharma or niti sometimes comes at a cost, and that is very heavy. So would a more nyaya focused approach help? So we saw in our two examples what happens if, supposing you apply the law. In the case of bigamy, if you apply the law, the second wife will be stigmatized, the relationship will be spoiled, the child will be only looked at as an illegitimate child. Disastrous consequences. If you go ahead with the partition suit, if you decree the suit, again disastrous consequences. The relationship is broken forever. The brothers are never going to see each other's faces again. The relationship is completely broken. So the question is, would a more nyaya focused approach help? Can we look at the consequences? Now maybe, see, in the context of Mahabharata, considering that Lord Krishna's efforts to make Duryodhan come to an agreement with the Pandavas failed, there may not have been any other recourse. But in our day-to-day life conflicts, the consequences of applying Niti need not always be so disastrous. So Amartya Sen says that justice is ultimately connected. I'm quoting. Justice is ultimately connected with the way people's lives go and not merely with the nature of the institutions surrounding them. Now, there are two questions that I want to place before you and want you to ponder upon. Unfortunately, in the online platforms, it becomes very difficult to have a conversation, because normally I prefer to have a discussion along with the talk. But it becomes difficult because then you have to unmute everybody and there's a lot of noise that comes, background noises come. So it upsets the whole thing. So we will reserve the questions to the last. But I want to place before you two questions that I want you to ponder upon. One is, are we really serving the cause of justice by simply applying the law to all cases and delivering judgments according to the law? And number two, are we overburdening our justice delivery system by taxing it with the job of resolving disputes, in addition to its larger duty of ensuring social justice? Now, if you just go back a little in time, there was an alternate theory. We discussed about the social contract theory. There was an alternate theory, which is not necessarily contrary to the social contract theory, but it's called as the social choice theory. That actually emerged from a number of other philosophers. There was a period called the Enlightenment in Europe. A lot of questions were asked and a lot of thinking, a lot of philosophers came up with their brilliant ideas, and that is how Europe changed from a strictly religious continent to a more secular setup. So scholars like Smith, Condorcet, Marx, John Stuart Mill, they adopted a more analytical approach by comparing how institutions influenced people's lives as against people's actual behavior and social interactions. Now, the difference between the two theories lies in this contrast between an arrangement-focused conception of justice, that is, having the courts and having the law, and the other one is a realization-focused understanding of justice. So the first one, the arrangement-focused conception of justice, concentrates more on the actual behavior of people, rather than, the realization-focused understanding of justice concentrates more on the actual behavior of people, rather than presuming compliance by all with ideal behavior. See, the reality is that no matter how proper the established institutions might be, Amartya Sen says that if a big fish can still devour a small fish, it is a failure of justice. So when you are trying to establish a perfectly just society, are you really succeeding in preventing manifest injustice? We are not. So justice fails sometimes, and that is what we see happening in society many times. Now, the question that we need to ask in this context is whether it is enough to just have the basic institutions and laws right, or should we also examine how these actually have an impact on people's lives, on the actual lives that people lead? So, with our present arrangement focused approach to justice, are we able to provide people with justice, with access to justice? What should be the kind of justice that needs to be provided? Should it have a purely deontological approach, as symbolized by the maxim fiat justitior vot caelum, or should it be justice that answers the actual needs of the people, not just the substantive needs, but also their emotional needs? Because ultimately, what is the purpose of all this? Ultimately, the purpose is to ensure that there is social harmony. There is harmony in society, conflicts are resolved, disputes are resolved, and people are able to live in peace. So for this, we need to understand the distinction between justice in the context of social justice and justice in the context of dispute resolution. Now, if you see the former, social justice, we need our institutions. I've already told this before. We need our courts. We need the law. Because these are all, hard-fought rights. Now, for the latter, we need systems that would not simply apply the law, but also look into the other facets of the conflict, including the emotional and psychological needs of the people, the stakeholders, the disputants. If that fails, only then we need to invoke the law. So this, excuse me, this realization-focused approach to justice, if you look at it from the perspective of access to justice, it needs to satisfy 5 criteria. It should be cheap. It should be speedy, fast. It should give parties control over its trajectory. Now, what happens when you go to the court? If a litigant goes to the court, he loses control. He has no more control over how the dispute is going to go, what path it is going to follow. He has no control over it. Number 4, it should empower people to determine the outcome. Now, what happens is in the adjudicatory processes, basically, the outcome is determined by a third person, a neutral third person who has nothing to do with the dispute. That person decides who's right and who's wrong. Okay, and the parties, the disputants themselves, the real stakeholders, the affected parties have no say in the matter. Ultimately, it all depends on how much they can prove, what they can prove, what the law permits them to prove, and how far they can establish their rights. And that again is determined by so many procedural laws, the laws of evidence, blah, 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 so on. Number 5, it should respect their privacy. So it should be cheap, it should be speedy, it should be under the control of the parties, it should empower people to determine the outcome, and it should respect their privacy. So what we need is a process that treats people as human beings, not as just subjects. Okay. I don't know how many of you have seen, I think Kamala Hassan acted in the movies. Munna Bhai MBBS was a very famous Hindi movie in which when the doctor, the dean of the college talks about, subject, Munna Bhai objects and says that, why do you call him a subject? He's a human being. So, but in law, unfortunately, we regard people only as subjects. We don't treat them as human beings because there's no scope for understanding how they feel about it. So we need a process that treats people as human beings and not as subjects. A process that provides them with an opportunity to articulate their real interests and not merely their positions, which are defined by some abstract principles of law, because the law defines rights and obligations. So normally people are confounded by these definitions. So those are called as positions in our mediation lingo. So not just by their positions, but what are their real interests? What will help them to come out of this dispute? What will help them to move forward? What is good for the future? Then the process has to give them the procedural flexibility, control, and autonomy, and that also fulfills their needs, and not merely some abstract notions of the rights which are defined under the law. So here is where mediation fits the bill. It is cost effective. It is expedient. It dispenses with strict legal procedures. It provides autonomy and flexibility to the disputants to solve their problems, to find innovative solutions. And above all, it treats people as people and not as subjects on whom some, abstract legal principles should be applied. So essentially, it fulfills the constitutional promise of access to justice, justice that is more focused on the consequences and their impact on their lives, and not just an abstract definition of justice under the law. I hope I'm able to bring this distinction clearly to you. Now, having said that, let me add one word of caution here. Now, there are certain types of disputes that may seem to be amenable to mediation, but would actually fall under the realm of social justice. To just give you an example, domestic violence. Okay, domestic violence happens in a relationship, maybe a marital relationship. But if it happens, is that case amenable to mediation, or should the law take its course? This is a question that sometimes, that really is a question that a lot of people are worrying about when they talk of mediation. No, there are some hard-fought rights, caste rights, gender rights, minority rights. Now, the violation of these rights require judicial intervention. No, justice has to be done from the social justice perspective. Now, these are not cases that may be, because here there might be oppression, because a more powerful person may take advantage of the power that the organization or the government, or the power that the government also holds to oppress people. So we cannot allow that to happen. So we have to be cautious here that under the guise of dispute resolution, such violations do not escape the strong arm of the law. Now, attempts have been made to define the different categories of cases that are amenable to resolution through mediation and those that cannot. If you look at the AFCON's case, I think it is 2010 Supreme Court, 2010, Supreme Court, where the Supreme Court has given a list of cases that are amenable to mediation and that are not. But this is a matter for another discussion, maybe some other time. Now, what we need to understand here, and my effort here is to, help you to understand that contrary to popular perception, mediation is not an ad hoc process meant only to clear the backlog of cases. Yes, that is one of the purposes that mediation can fulfill, so that the courts can be free to decide on the larger issues of social justice. But it is much more than that. It is a highly nuanced, sophisticated, technically refined process that can, complement the existing institutionalized justice delivery system. I'm using the word complement, not supplement. And it can help in fulfilling the constitutional promise of access to justice. Justice that is more realization focused, justice that can have a more positive impact on the actual lives that people lead, rather than justice that is based on some notional abstract principles. See, we need to change the whole paradigm of how we understand justice and dispute resolution and our role as lawyers. Are we going to take every case to the court? Are we problem solvers or are we problem inflamers? Are we mere mercenaries whose job is to shoot and kill for those who hire us? Or are we responsible professionals who would use our skills to collaborate and solve our clients' problems? Now, this is the call that we as lawyers have to take. Which would be the best way to help our clients to move forward, to resolve the problem? If supposing you find a cockroach running on your kitchen sink, are you going to take a sledgehammer and hit the cockroach with that? You're not going to do that. You may probably search for a spray and then spray it in your kitchen sink. Okay. Now, just as Ravindran in an article which I had read earlier, which I always refer to, has given this beautiful example of a hospital. So he's comparing the court to a hospital where, for example, if the government sets up a hospital and a beautiful 25-bed hospital, all the amenities, all the facilities, everything is there, but appoints only a surgeon. Not every patient requires a surgery. Some problems like a headache or a stomach ache can be solved through medication. So what you also need is a general physician. So if you don't have a general physician, what is the surgeon going to do? Is he going to operate on all the cases that come? That is what is happening today. And fortunately, the good news is things are changing. So we have a mediation center that is working. We have laws mandating mediation. You all already know about Section 89 CPC. You know about Section 12A of the Commercial Courts Act, which mandates pre-litigation mediation. We have the new Companies Act, the Consumer Protection Act. All these have provisions for mediation. Now, recently, I don't know how many of you are aware, the Bar Council of India has issued a circular mandating the teaching of mediation in law schools. And what is interesting is when the mediation center started, we used to, Mr. Sriram Panchu tells us how he used to struggle to get lawyers to join the mediation training programs. Today, I think Adi Lakshmi will vouch for that. We have a waiting list of people wanting to get trained as mediators. So, my friends, what we need to do is we need to understand to what extent we need to apply our court system and to what extent we need to apply processes like mediation to help people to resolve their disputes. So I want you to basically, I want to conclude on this very positive note of what's happening. And along with that, I want you to keep in mind these two things. That one is, by taking recourse to more collaborative processes of dispute resolution like mediation, we are actually removing the burden from the courts. We are allowing the courts to have more time to focus on the larger aspects of social justice, to deal with habeas corpus cases, to deal with cases where people's rights have been trampled upon. All these matters require the intervention of the courts. Now, the courts don't have the time simply because they are burdened with matters which can easily be resolved by sitting and talking to the people, by a skilled intervention, through skilled mediators who can talk to the parties and bring about a resolution. Why can't we do that? Is the question that I would like you to ask yourselves. Now, here I'm not saying that everybody should get trained as mediators. There is also something called mediation advocacy. It's completely different from litigation advocacy because your whole approach changes. From an adversarial approach, you have to change your mindset to a collaborative approach. From a problem inflamer, you have to become a problem solver. So mediation advocacy is going to be in a very short while, because you see, mediation is one of the biggest disruptors that happened. And now after COVID, technology has taken over. Technology has become one of the biggest disruptors of our legal system. So mediation has challenged a lot of, paradigms of that this is how a dispute can be resolved. This is how, this is the only way in which, if you have a problem, the only option is to go to the court. No, there are many other options available to you. So look at those options, see how this can be resolved. Does every problem need to be adjudicated? Do we always have to find the right and the wrong in every matter? These are questions that we need to ask ourselves, and as lawyers, as responsible members of the society, and it is our duty, because we are basically officers of the court, it's our duty to ensure that people have access to justice. Now, mediation being, a lot of disputes don't come to the court. Why? Because people simply don't have the means. Now, we are talking about technology. We are talking about virtual hearings. We are talking about online mediation. So there is a whole paradigm shift in the way, conflict resolution is being looked at today. So we are today talking about digital dispute resolution specialists, people who will be intervening and who will be resolving disputes, applying the most appropriate method of dispute resolution to that, whether it is litigation, whether it is arbitration, whether it is going to be mediation. So these specialists will be determining those outcomes. This is the future. This is what is going to happen. So we cannot, shy away from the future. We cannot avoid the future. It's going to take over. Okay, we have this tendency to protest against everything. Yes, we need to protest. That is a fundamental right to protest. But when we are protesting, we should also keep in mind that there are things that are happening, and we need to uh, recognize those changes that are happening all over, particularly changes that are being brought about by technology. And we have to see how we can balance this with people's rights, how we can ensure that we can use this technology to ensure that people in the remotest part of the country. I was talking recently on some webinar, and I said that we have ATMs in different parts of the country. Why can't we have, kiosks with trained people? We can create employment for, technically qualified youngsters who can manage these kiosks, who can manage these centers, where people from the remotest part of the village, they can just go there and tell them what the problem is. And then they have a system where they can feed in the problem, and that will give you the answer as to what would be the most appropriate. And sitting there, a villager can resolve his land issue sitting right there in his own village in the comfort of the either either the kiosk or in the comfort of his own house. He can sit there and he can ensure that this problem is resolved. So I mean, the possibilities are numerous. Okay, all we need to do is look at it from a positive perspective, and we need to take this forward. So on this positive note, let me end my talk.